You've never been in trouble before. Maybe you've never even had a parking ticket. You have a job, a life. Maybe it's someone in your life that you care about, and now you are being treated like a criminal. If you were just arrested for domestic violence and you're thinking, this can't be happening, this is not who I am, you are not alone. But here's the hard truth. Right now, the system doesn't see the full story. And because it doesn't see it, it does not care about your background, your reputation, or how all of this really unfolded. In this video, I will explain exactly how the process works and what you need to do before your first court date. By the end, you'll learn why the charges don't always reflect the truth, why your side of the story has not been taken into account yet, and most importantly, how to take action now before it is too late to change how the system sees you. My name is Veronica. I'm a domestic violence criminal defense attorney, and I help people throughout the entire state of California put their cases behind them so that they can enjoy their lives and their freedom. So let's jump right in. How to show the system that you are not a criminal. Most of the men who come to us, to my law firm, we only handle domestic violence cases, they are not career criminals. They're fathers, workers, boyfriends, husbands. One argument escalates, one phone call gets made, and suddenly the system has labeled them as dangerous. A felony domestic violence conviction can mean jail or even prison, loss of your job, and a record that follows you for life. And even a misdemeanor domestic violence conviction cannot be expunged. It cannot fully be erased from your record ever in the state of California. Take this scenario. A man and his partner are driving home after a night out. She starts hitting him while he's driving. He pulls over and asks her to get out. The delivery driver sees the last 20 seconds, misinterprets it, and calls 911. Next thing he knows, he's charged with domestic violence even though his partner isn't even pressing charges. He walks out of jail the next morning with the clothes that he wore to dinner. This kind of thing happens more often than you think because once law enforcement steps in, it stops being about what actually happened. If you were arrested, you probably saw this firsthand. They make the arrest based on very little evidence. It becomes about what they think they can prove. In California, police are trained to arrest someone if they see any sign of domestic violence, even if the alleged victim does not want to press charges. So this could mean someone's statement with nothing else. It could mean a bruise or something that someone said on a 911 call. The idea is to protect real victims from being pressured or silenced. But it also means that someone like you, a genuinely good person caught in a bad moment, can be arrested without anyone actually taking your side of the story into account, even if you tried to tell the police. There's generally barely an investigation. If there's even a claim of injury, they often treat it like a confirmed crime, even if it was self-defense. Now, the system does not care that you've lived your whole life without a criminal record. I've heard DAs say there's a first time for everything, and it's true. Everyone who has a criminal record once did not have one. If you do nothing, they don't care though that not only do you not have a criminal record, but maybe you are a provider, a parent, a decent human being. All the DA will get after your arrest when they are making a decision as to whether or not to file charges, and if they're going to file charges, should it be a felony or a misdemeanor, is the police report. And if that report tells a one-sided story, and it does, you are going to be seen as a threat, not a person. Even a small injury can lead to a felony charge. There's a charge called corporal injury to a spouse or cohabitant. It sounds extreme. All that it means, though, is that some injury was visible. A red mark, a scratch, a bruise, sometimes something that was actually pre-existing or is not an injury at all. But once the police believe that there's an injury, it is usually booked as a felony. If there's no injury, it's typically charged as misdemeanor domestic battery under PC 243E1. But again, even that carries serious consequences. Now, the police report, the report that is created by the officers who arrested you, that becomes the entire foundation of the prosecution's case against you. Prosecutors use it basically like a cheat sheet. But let's think about this. It is often written days later based on memory, impressions, and sometimes, many times, outright misstatements. It may leave out context. It may ignore what you said. Sometimes it even distorts what the alleged victim said. Even when you try to explain yourself at the scene, your side of the story is often reduced to a sentence like, suspect denies domestic violence. That's it. That's what the DA sees. That's why when I review a police report with a client, which we often get before we actually have any body-worn video or anything to confirm whether or not it's true, I ask them, does this match what you said? If you know what the alleged victim said, does it match what they said? Did they take any photos of you? And once I get that body-worn video, which is far more important for the defense than a police report, does the police report match the body-worn video? A lot of lawyers don't do this unless the case is going to trial, but one thing I always do is get transcripts of the body-worn video. Because many times the prosecutor is not looking at the body-worn video. I mean, it takes significant time to do so. And I want to be able to quickly show them problems with the body-worn video, things that help my side of the case. In one case, the prosecution was trying to get my client to take a year in jail for felony domestic violence. But I watched the body-worn video, I got a transcript, and the body-worn footage did not match the report. I talked to the DA. I showed the DA exactly where the inconsistencies were. I mean, it wasn't an airtight case for really either side, but the injuries that the alleged victim seemed to have in the body-worn video did not match the way that she said that she got them. The DA had not watched any of the body-worn video. I had to show it to him on my own laptop, which I had marked to exactly the spot in the body-worn video that I wanted to show him, along with giving him a copy of the transcript. In the end, he agreed that if my client did 10 online anger management classes, then he would dismiss the case. That's the power of getting ahead of the story. If you don't have someone who knows how to do that, or who puts the time in and this attention to detail to actually do that, you may never get the chance. Now, one of the first things that my firm does when we get a new client who's been accused of domestic violence is build a mitigation packet, especially if charges have not been filed yet, if the client has not been to court yet. This is to show the DA and the court who you really are. This might include letters from family, friends, employers, community members, proof of employment, evidence of parenting responsibilities, a letter explaining who you are as a person, photos of any injuries that you sustained, and voluntary steps like anger management, or if alcohol was involved, even if you weren't an alcoholic, just drank a little bit too much that night, AA. But not all of these mitigation letters and packets are equal. Some lawyers submit generic sort of cookie cutter material and it reads like a resume. I mean, every client, every person has a different story. One might be a father and provider. Another might be in recovery. Someone else might have an impressive career trajectory or at least dreams for the future. We're looking for an angle. What makes this a one-time mistake and this person a good person deserving of a second chance instead of this being a pattern? So to do this, we ask every client 20 to 25 or so specific questions so we can build a real story of who you are. If you tell us something that we can't use or that's not helpful, then we won't include it. But we want to paint a picture of you as a person because for most of our clients, this is their first arrest. They are scared. They have a lot to lose and they want to make sure that it never happens again. Now, I've seen mitigation letters from high profile lawyers even that completely miss the point. One that I saw not too long ago was meant to prevent felony charges against a doctor, a medical doctor, but it didn't even mention that he was a doctor. No information about his character, his family. He was really involved in the community too. Nothing. So the DA, of course, ended up filing felony charges. DAs do read these packets, but it is important to really make sure that they get them because the system is not designed to help defendants. If the packet gets lost, if it gets misplaced by a clerk in the DA's office, no one's going to track it down. No one cares. No one gets in trouble. So for my office, we send it multiple ways. We will fax it, mail it. If we have the DA's email address who's looking at it, we will also email it. And then we will follow up to confirm that it is in the file. We'll make sure that all the identifying information about the arrest is in there so that it can get to the right source. That's something that also doesn't happen a lot. So basically, these mitigation packets go to the DA's office. Maybe they're mailed there, but they just go into the void, basically. That follow-up is essential to make sure that the DA actually has that in their file when they're reviewing the police report and making a decision about your future. And we start that process immediately of asking those questions, of gathering the character letters, of preparing this packet, because if the DA opens that file and all they see is the police report, that is what they will base their decision as to whether to file more serious charges than what you were arrested for, less serious charges, go along with what you were arrested for, or we hope drop the case altogether. That is our goal. If we can get it dropped before court, then you can put the whole thing behind you. You avoid months or, in some cases, years of stress with this thing hanging over you. Once charges are filed, you are in the system and now you are fighting from behind. And one of the questions that I get asked a lot is, what's the deadline? When is the DA going to look at the police report? When will they make their decision? I cannot answer that question. It is up to them. I have seen them only a few days after the arrest, a week after the arrest or so, make a decision. I have seen them not even make a decision before the first court date, and they will take weeks or months after that to actually get to it. Basically, we're talking about a pile of documents, files on someone's desk and how quickly they get to them. So for me, the deadline is as soon as possible. We want to make the mitigation packet good. We want to make it strong. We want to have proof of enrollment and any sort of programs that make sense for you to do for your case in there. But we are not going to wait for you to get a bunch of, if you're doing therapy, weeks of sessions in before we submit this thing, because by then it might be too late. And once charges are filed, you are in the system and now you're fighting from behind. Now, as a domestic violence defense attorney, my job is to make sure at this stage of the case before charges are filed that the DA sees the full picture, not just accusations. Let's say a man is charged after a loud verbal argument. No injuries, no weapons, but now a neighbor calls 911 and he's facing a misdemeanor. If he shows a clean record, parenting responsibilities, community support, it sends a message. This was a bad night. This is not a dangerous person. In over 75% of cases where clients contacted us early, this is for our cases from last year for clients who signed on with us whose cases were resolved. People who contacted us before charges were filed, by using this process, we got the charges, the entire case dropped. Every week I'm telling clients that their case has been dropped, that no charges are going to be filed. But I also get calls from people who waited too long. Now they are charged with a felony. They are being told by the DA that they want a year in jail, and they are asking what now? And look, it doesn't mean that it's impossible, but once charges are filed, there's a courtroom DA whose job is to prosecute you. You are one of the people that they are trying to prosecute, that they are trying to convict. And now you are trying to basically undo a decision that is already in motion. And most prosecutors in most counties in the state of California operate in systems with a 95% conviction rate. Last year, though, over 95% of my clients avoided conviction. That includes people where charges were filed. But in those cases, when charges have already been filed, or when we submit a mitigation packet and the DA decides to charge the client anyway, that outcome takes a lot more work. Classes, motions, court hearings, and maybe trial. And the truth is that there is more risk. If you lose at trial, you get convicted. And a judge can sentence you to the maximum allowed by law. Early action is not just helpful, it's the difference between walking away quietly and getting pulled into a system that can derail your life. If you wait, or if you wait to get a public defender at your first court date, you may never get a chance to tell your side of the story. And the consequences are permanent. Jail, probation, restraining orders, a permanent record, loss of employment, custody, or sometimes for some people even housing. And you don't get a public defender until after charges are filed. At that point, you're already behind. The opportunity to avoid charges entirely, that is gone. And in California, if you want someone advocating for you early, you have to hire a private attorney. That is the only way to get someone contacting the DA, submitting mitigation materials, the good things about you, hardships you've experienced, that you are a good person, that you're not just however you're described in the police report, and someone fighting to stop the case before it starts. And yes, there is a point of no return. If you show up to your first court date without a lawyer and formal charges are filed, you will be expected to enter a plea. And the system has decided that you are a defendant. There will be a case filed that's people against whatever your name is. That's why it's so important to take that opportunity to be proactive, to get your side of the story out there so that the system can see that you are not a criminal. This was one bad night. This was a mistake. This was a misunderstanding, but this is not you. I hope that you found this video helpful. If you do have a domestic violence criminal case in California, feel free to book a consultation. You can find my number down below. You can also book directly via the Calendly link there. And if you did find this video helpful, please don't forget to like, subscribe, ring the bell, and if you do have a question or a comment, leave it in the comments.